Good evening, ladies and gentlemen, and welcome to tonight's meeting of the Committee of Adjustment. This is a meeting to consider applications for minor variance and consents that's held under the authority of the Planning Act of Ontario. Please keep in mind the intent of our process is to review the proposal that's before us, listen to all the evidence, and then make a decision. This process is not intended to be used to resolve any concerns or disputes that may exist between the town, individuals, or any other organization. If a request for a deferral is made this evening and the committee grants such a request, our committee, after we consult with our Secretary-Treasurer, will set a new hearing date. No further notice will be provided on the application unless there are changes to the application. In order to conduct an effective and efficient hearing, we have adopted the following process. The owner or authorized agent will be given the opportunity, if so desired, to briefly explain to us the basis of the application and answer any questions that may arise out of the hearing. A maximum of 5 minutes will be provided for this presentation. You need to state your full name and address for the record, and any materials that's submitted to the committee for viewing will remain the property of this committee, and any submissions beyond the 5 minutes will be at the discretion of this committee. All persons attending the hearing this evening who wish to support or oppose an application must also state their full name and address for the record. A maximum of 5 minutes will be provided to make your presentation, and all remarks and questions are to be directed to the chair of the committee. Any submissions beyond the 5 minutes, again, will be at the discretion of this committee. If there are several speakers that share the same view, we encourage you to elect a spokesperson to present the group's combined opinion. We want to hear all the different and varying points of view. However, covering the same points and expressing the same concern doesn't assist us. The owner or agent will then be provided with a further 5 minutes to respond to comments made by any interested parties and answer any questions from the committee members. If the owner or agent has any concerns found in the staff report, particularly with any of the proposed conditions, this will be your opportunity to let us know that. The matter will be then taken to committee for a decision, and that will mark the end of all discussion. Once the committee makes an oral decision, any person desiring a copy must file with the Secretary-Treasurer at this meeting a written request for notice of decision. And to assist you, we have green sheets in the back table that we ask that you fill out and leave with us before you depart tonight's hearing. Please note that you must make a written request in order to be included on the list that is used by the Intermunicipal Board for the giving of any subsequent notice of any appeals. Written notice of our decision will be mailed not later than 10 days for minor variance and 15 days for consents to the applicant, the owner, agent, or any other person who's filed a written request for such notice. If you do not agree with our decision, you may appeal this to the Ontario Municipal Board. The last date to appeal the decision to the Ontario Municipal Board will be noted on the decision itself. If no appeal is received within the prescribed time frame, our decision becomes final and binding, and the Secretary-Treasurer will then notify the applicant or the agent or the owner through written correspondence. People attending this committee meeting are to be courteous to and respectful of the members of the committee, town staff, and other people in attendance at the meeting tonight. And also just to let everyone know that tonight's meeting will be live streamed and available for future viewing on the town's live stream page at oakville.ca/live. So if anyone wants to go back and have a look, it's available. And we ask that you turn off all your cellular phones and pagers, but at least put them on silent. It tends to interfere with the audio system, so if you can assist, that'd be great. And we are ready to start our hearing. Is there any regrets this evening? See none, everyone's here. Is there any members here that have a declaration of any pecuniary interest? Okay, everyone's nodding in the negative. Is there anyone here this evening that wishes to either defer or withdraw an application? Okay, I see 3 hands, whoever's closest. Okay, you're going to have to speak up.
It's for application CAVA 206, 2016. That's correct.
Can we get your name and address for the record, and then we'll deal with your request?
Name is Stephen Hamlin. Address is 145 Lakeshore Road East, Unit 200, L6J 1H3. Okay,
just very briefly, the reason for your deferral request?
It came to my attention today that there's a mistake on the variance request for the maximum residential floor area ratio. The variance, the proposal here is stating it's asking for 42.25%, when actually the calculation is done incorrectly. It's actually 43.16%. It is going higher. That's correct, yes.
Any notice deficiencies?
Pardon me?
To correct any notice deficiencies?
That's right.
Okay, so just before we deal with your request, is there anyone here this evening that has an interest in application CAV 206-2016 at 1316 Acton Crescent? You do? Okay, you heard that there's been a deferral request to correct some anomalies in the application? Yes. Okay. Any submissions on that very quickly? Okay, well, if you're going to talk to us, you're going to come down and register your name and address. Just as you are on your way down, just to let you know, the committee normally grants a deferral request on such.
If this is for the side yard reduced setback, we are going to be deleting that variance.
Well, okay. Well, we're not getting into, hang on, just one at a time. Let's get your name and address for the record.
Yes. My name's Chris Ritz. I live at
Okay.
1373 Constance Drive, Oakville, Ontario.
Okay.
Postcode L6J 2T8.
Okay, and just to confirm, you had a side yard setback concern. Is that what it was?
Yep. So from my understanding with the applicant is they want to move the house forward and shrink the sides
Yes?
according to the bylaws.
Yes.
So those are my concerns. It's
Okay.
just obviously the side part and moving the house forward too. We
Okay.
just recently built too a couple of years ago.
Okay.
So we work
All
under the
right, so that
bylaws.
doesn't go to the deferral request. You've
Okay.
expressed your concern, so what we'll do is, everyone agreed to a deferral? Question? Yes?
Just a question for planning. I had sent you an email earlier today about this one. If you could, so the question I had was that the lot size was, bear with me,
Okay.
870.58 square meters, but the variance was for residential floor area between 650 and 742.
Okay, we're not, so let me just cut to the chase. We're not going to deal with the specifics of the application. Obviously, there's some,
But it goes to a problem within the variance. There's no sense in having him come back asking for 43.16 if the thing he's varying is wrong to begin with.
so,
No,
okay, let's, I think you understand the question, so let's get an answer. Does it assist at all in variance number 2?
it is about variance number 2.
Okay, let's go. Let's have
Yes,
it.
thank you. Through you, Mr. Chairman, to the committee. I did receive the correspondence in the email, and I apologize for not getting back to you in time. The nature of the variance requested for residential floor area in this particular situation is the lot has a dual zoning, part of which the zoning is for a natural area. The bylaw excludes the portion of the property in area from the area calculation that would result in the floor area ratio that is provided. That is why there is a difference in the lot area as a whole, as indicated on the applicant's plans, versus what the variance is prepared as, which is a reduced lot area by virtue of the removal of the natural area that's part of that property.
That's fine. So there is no error then here in terms of this.
Not with respect to how the lot area is being defined.
Good.
All in support of the deferral request? All right, the matter is deferred. So you might take the opportunity to speak to your neighbor while you're here and see if there's any discussion that can result in some sort of understanding on the variances, all three, or whatever remains.
Thank you very much. Okay.
Thank you. Have a good evening. Good evening, sir. Name and address for the record.
Good evening, Mr. Chairman. My name is David Brown. I'm a planning associate at David Small Designs. We're the authorized agents for the owners of the property at 355 Sawyer Road, which is item CAV A201-2016 on your agenda.
Okay, thank you. Is there anyone here this evening that has an interest in application CAVA 201-2016 at 355 Sawyer Road? Okay. Sir, just very quickly, the nature of your deferral request?
Having reviewed the staff report with our clients, we have decided through some discussion that we're going to look at revising the proposal to reduce or ideally eliminate all or some of the variances and bring that matter back before the committee once we have the revised proposal. Specifically, we're looking at the floor area and how that could be reduced, which will tie into the garage area, reduce the coverage, and bring an application closer to compliance with the zoning bylaw. If not quite compliant, we'll be back before this committee, but it is our intention to try to eliminate that.
Okay. Have you talked about when this matter can get back on the agenda?
I haven't had that discussion. I'm thinking that something either early February or
Okay.
beyond would be
So
an
we're not going to
appropriate
assign
date.
a hearing date. We're going to leave it to you to determine, just like we would do with the last application.
Fair enough.
Because I think our agendas for the next little while are quite full, so it depends on when the Secretary Treasurer can get it on, which means regardless of the changes, there'll be a new notice.
Yes.
Is there any questions? Sir, you indicated an interest. This matter is going to be deferred? Okay. So we won't register your name and address at the moment, but we'll invite Mr. Brown to connect with you and have a discussion on the application. All those in support of the deferral request? Okay, this matter is being deferred, and we'll leave it up to you to determine when you can get it back on the agenda.
Thank you, Mr. Chairman.
Thank you. Anyone else? We're on a roll.
Mr. Chairman, committee members, my name is Paul Wright from ACI Wright Architects. Regarding 2913 Sherwood Heights, CAVA 205. And we respectfully request a deferral.
This is a hotel, yes?
Yes.
Okay, and nature of the deferral request?
We had discussions with planning, and they've requested a justification report from us, and they would like us to do that, so they would like us to defer it, so we're happy to do that and provide that to them.
Okay, is there anyone here this evening that has an interest in the application CAV A 205-2016 at 2913 Sherwood Heights Drive? Oh, okay. We might have half the room empty for at least tonight. Okay, so there's been a deferral request, and as you heard on the two previous ones, usually the committee grants such request. But sir, if you have a turn around for a second.
Yep, no,
You know
aware.
them all?
Yeah.
You saw the people that showed an interest?
Yes, absolutely.
I would encourage you strongly to connect with them before you leave tonight, and maybe even consider having some sort of a little meeting with them.
Yep.
You know, formal or informal, to garner whatever concerns there are and try to address them through the process with planning staff. Members, any questions about deferral? All those in support? Okay, this matter will be deferred. Invite you to connect with your residents here and see if you can marshal some support.
Okay, thank you very much.
Okay. Anyone else wishing to defer or withdraw?
Good
Okay,
evening.
thank you.
My name is Antonio Mastriani. I'm the owner of 602 Parkside Drive, and I wish to, for a deferral.
So this is application CAVA 200-2016 at 602 Parkside Drive.
Yes.
Is anyone here this evening that has an interest in the application CAVA 200-2016 at 602 Parkside Drive? Nature of your deferral request?
I'm waiting, I've just filed for a tree removal, so I'm waiting for that decision on that tree.
Right, okay, I remember that. Ms. Mihaljevic, you were going to indicate the same thing?
Yes, thank you, Mr. Chairman. Through some additional research and discussion with the applicant, it's been determined that in staff's initial comments, we had indicated that we weren't clear as to whether or not an access permit and subsequent permission to remove the tree had been granted. It has been determined that a permit for access was granted in 2014, but we authorized the removal of the tree at that time under a different set of policies. Our policies have since changed, the tree remains, and so unfortunately the applicant is now subject to the revised removal of the tree policy, which he needs to go through an application submission process to confirm whether or not the tree can be removed. The deferral would allow the opportunity to determine the outcome of that process and ultimately decide whether or not a redesign of the project is required if that tree is unable to be removed.
Okay, how long will that process take?
Through you, Mr. Chairman, I'm unclear as to how long. We are getting towards the end of the year. I suspect that it would be a result in the new year. That being said, if the determination is that the tree cannot be removed, I assume that the applicant would require some time to revisit his proposal in order to make any necessary revisions before coming back to this committee, if at all.
Okay, so I guess this is another one that we're going to leave it open for, to bring it back like adjourn, sign, and die. Unfortunately, we don't like doing that, but circumstances are such that it's probably prudent to go down that road so to let everyone ample opportunity to work things out. Okay, any questions? Everyone in support of the deferral request? Okay, thank you. The matter's been deferred, sign of
Okay.
that, and then we'll invite you to
Thank you.
do what you need to do and bring it back when it has to come back. Thank you. Okay, anyone else? Don't be shy. Deferrals, withdrawals? Okay. I should have also mentioned there's a deferral fee, but I think they all know that, eh? Okay. Okay, let's start with our consent application, which is bundled together with two variances, and this is consent B1611 at 401 Englehart Street South. It's bundled together with minor variance application CAVA 180 2016 and CAVA 181 2016, again for 401 Englehart Street South. Good evening. Name and
Good.
address for the record.
Good evening, Mr. Chairman. Nancy Friday, Wellings Planning Consultants.
Good evening. So is there anyone here that has an interest in these three applications at 401 Englehart Street Drive, B1611, A 180 2016? Okay. All right, so there's a show of hands, so we'll invite you to do a presentation.
Sorry.
Can we dim the lights a bit, please? There we go.
There we go.
Is that good enough for everyone? Maybe back out a bit. Maybe back out a bit. There we go. Perfect. Thank you.
Oh. Alrighty. Now, does my little laser work on here? It does.
Yeah,
Okay.
it does.
Okay, the property we're speaking about this evening is located south of the QE. It is east of Trafalgar Road. It is west of Reynolds Street, and it is north of Spruce Street, and it's located right here, and it's 401 Englehart Street South. So the lands are zoned RL5 with the suffix, the 0 suffix. So the existing lot frontage of this lot right now is 21.6 meters, which is approximately 71 feet. And it has an area of 731.6 square meters, which is 7,875 square feet. It is designated low density in the official plan. I'm actually going to, unfortunately, shift now. So previously on this property, 401 Englehart, it's just like it should be, straight up and down. Okay. So this shows the dwelling that was on the property previously. It has been demolished. So previously, this is was a legal non-conforming 4-unit building with a circular driveway in the front. The dwelling has been removed, as I said, but it did have a couple of balconies or decks on both sides of the dwelling and into the rear yard as well. So the dwelling and 2 trees were removed from the property in accordance with the town's bylaws. Pardon me?
The 2 trees were removed, did you say?
Yes.
With permission?
The existing, yes. The trees. The demolition permit for the building and approval to remove the 2 trees from the property. So the existing lot frontage and area right now, it falls somewhere between actually an RL2 and an RL3 zone, even though it is in the RL5 zone. It's 37% larger than the minimum lot area required in the LR5 0 zone. So the proposal is to vary the front yard and the lot, the front lot frontage and the lot area to permit a severance of the lot and to construct 2 new dwellings. So the lot frontages proposed are 10.71 meters, and that's 35 feet, and the lot area is 365.8 square meters. So as I mentioned, the variances are just for lot frontage and lot area. All other regulations in the RL5 zone will be met, including building lot coverage, setbacks, height, and floor area. So as you can see on the sketch, the severance sketch that's up on the screen, the front yard, I don't know if you can see it, the front yard to the porch is 7.5 meters, and it's over 9 meters to the building. We have a rear yard instead of the 7.5, it's just over 11 meters. There's a just over 3 meter side yard between the two existing lots on the other side of this lot. And so all the other, and the lot coverage, the floor area ratio, the height, everything is meeting the RL5 zone requirements, with the exception of the lot frontage and the area. Now, each dwelling will have a gross floor area of approximately 155 square meters, which is 1,670 square feet. And as I mentioned, it'll have a porch, and there's a rear detached garage, which is not for both dwellings. And these features were designed because they're prominent features in the neighborhood to fit into the character of the area. Now, in terms of the official plan, it permits a severance in a stable neighborhood, which this is, when it is compatible with the lot areas and lot frontages of the surrounding neighborhood, and it successfully addresses policies in the official plan, being section 11.1.19. There's 12 policies in there to address intensification or infill in stable neighborhoods. So we reviewed the lot sizes, as well as built form, dwelling designs, and heritage features in the area. The Trafalgar Heritage District, the subject lands are not within the Heritage District, but they do abut it. I gotta go back. So just in terms of lot frontages and lot areas, there are two.
We'll extend you another couple of minutes.
Oh, am I
but
too long?
Yeah, no, you have a bundle of applications, so we'll give you the
Yeah.
extension of a
And we do
couple
have the
more.
architects in the audience tonight. An architect would also like to speak briefly about the application.
Okay,
I'll make this quick.
thank you.
Okay, so there's been two larger lots severed in the neighborhood, one in 2003 and one in 2014. So the one in 2013 was on Englehart Street South itself, which is right here. And the other one is these two properties being 284 and 286, I believe, Spruce Street. So the two lots on Englehart have frontages of about 9 meters and 394 square meters. So they're 28 square meters larger than what is proposed here, but very similar in size. I wanted to mention that 261 through 269, these three lots here, have frontages of 10 and 11 meters each, similar to our proposed lots. And they have small areas at 319, 322, and 330 square meters. So they're 46 square meters smaller than the lots proposed at 401 Englehart Street. So town staff has stated that the lot frontage and the lot areas and the existing built form of housing along Englehart Street South ranges considerably. There's a diverse lotting pattern with many different shapes and sizes of lots. So town staff conclude, as do we, that the lot frontages and areas are not out of character, and they are not the same as all lots within the area, but they are compatible. And compatible here meaning they will coexist without unacceptable adverse impact. So one of the premier issues with this particular severance is, of course, the neighbors and some of the neighbors' concerns. So it was important to give consideration to the character of the area and whether or not these two new dwellings on these two lots would negatively impact the streetscape. So the architects that are with me this evening and will be presenting briefly prepared a heritage impact study as well as an urban design report, and they address the design guidelines for stable residential areas within both those reports, and they were available to town staff for review. So now if I could, I'll hand it over to John Sprossen, who will speak on the actual design of the dwellings and how they relate to the street and to the lots themselves.
Mr. Chair, Jonathan Sprossen, DQI. I'm the designer and owner of the property. Yeah. These are some of the pictures. What I want to do is, I guess, give you a bit of background. These are your reports? Yes. I just wanted to give a bit of the background to this project that we're doing here. We bought the property about 1.5 years ago. We had an idea to keep the existing house, which was a fourplex at the very beginning, but on inspection and having the insurance company go through, we couldn't keep it up. It wasn't in a state to repair or to keep, and taking it down meant we couldn't keep the fourplex use. So we decided that what would the next best thing be for the area, and we made a bit of a mistake in thinking that we could start the project without getting a lot of input from the town or input from the neighbors. So we had a thing called adverse possession on part of the property. So there was a 10-foot strip at the north end of the property that was in the 1980s was left off the description of the property. So it was deemed to be not owned by us. So it took about 6 months to rectify that and make it all under one title and one PIN. So that's been done, and that was a big delay. But while that was being done, while we had applied for that, we had a meeting with the neighbors. And we invited the councillors and stuff like that to tell them what it was that we were planning to do. And what we did from the first application, and we did have a variance in the first application for front yard setback, I believe, and garage, the setback from the garage. So we learned a lot from that. Part of which is that you shouldn't jump the gun and start putting things down before you have it all in place. And we made about 15 changes to that first application and tried to show all the neighbors what it was that we were trying to do, start to finish.
Tell us what it is that you said, because I thought you were going to talk about the design and,
I can tell you,
and the features.
So what we did is we decided that the setbacks were very important from the street, so we kept the front yard setback as required. We increased the side yard setbacks from 1.2 meters to 3 meters. We took the garage out of the house and put it in the backyard out of both houses so that it was more in keeping with the houses in the area. So these pictures here are 6 of the houses that are either on the street or on Spruce Street. We reduced the coverage, we reduced the floor area. We made the front porch that goes across the entire front, as you can see, as a common element. We reused the existing curb cuts, and locations for the garages were where the old sheds were that were taken down, and the houses were basically where the footprint of the house was. It goes from the back of the house and comes forward. This was to not disturb any of the trees around the property on the neighbor's property, because we are responsible basically for 6 meters into the properties around. So to preserve those trees and hedges, we kept the 2 houses back from the side. We followed all of the official plan and the intent of the official plan. The urban design guidelines, we met with the urban design people at the town and followed their guidelines, and also heritage, even though we're not in the heritage area. So the actual design concept, which is basically unchanged from our meeting of 1 year ago with the residents, is like this. So 2 similar buildings, but different in elevation. Large porches, separate garages, and 10-foot setback from the side yards, and 8 feet between them. So the idea was to not mock the houses in the area, not make them look like heritage houses exactly, but to do something that was more in keeping with the 21st century home. Our idea also was to have the 2 homes instead of 1 because we felt that a 3,500 square foot home wasn't in keeping in the neighborhood, and that was indeed allowable in the bylaw. And also a 2-car garage in front wasn't in keeping. So we thought this was the best solution for this particular site.
Okay.
I think that's
You ran out of time as well.
Okay,
Is
I'm
there anything
sorry.
else that you wish to add? Because we do have your reports. And you
Yeah.
know, we have read them as part of the package of material that was before us.
You have read them.
Well, they're right here, yeah, we
Yeah.
have, yeah. We
Okay.
also read the submission letter from Wellings and Associates too.
Okay, and one other thing is we did send out a circulation that we didn't put in, that we didn't submit. We just sent it around to about 45 houses in the area, and that was on the 5th of December, I believe, that went out. We hand-delivered it to each of the houses, just to explain how we progressed, because it has been a year
Yes,
since we were in front of everybody. So I got a copy for each of the members. Thanks, Heather. So if there aren't any questions?
Yeah, no, yeah, we're gonna see, is there any questions? Mr. Charlebois?
Yeah, just one quick burning question is that I think it keeps coming up from the residents too is, do you intend to build these houses the way
Yes.
they are? Because you present them as concepts, you don't present them as you know, saying this is what I'm going to do. You just present a concept saying that a building such as this can be built on this lot, which is true.
No, what we've, in talking to planning and in talking to urban design and stuff, they said it would be better to know what's going to go there. And since we are the owner and the builder, I think that we can, our idea was to present what we would like to see there. Will it be exactly, it's hard to say if it'll be exactly the same, but I would say that the envelope will be exactly the same. Changing window fenestration might happen because it is in the process of being designed. The size of the building won't change, the height, the setbacks, none of that will change. The size of the porch might change a little bit, but I think that's about it. The garage, you know, just the fenestration of the garage, the detailing of the garage might change a little, but the location of it will not change.
At this point, have these lots been sold then as concepts
Oh, no, you
to
can't-
buyers?
You
No.
can't sell them until you subdivide them.
Yeah, no, they're not sold. And the idea is to build them and then sell them.
And so,
Or
okay.
build them as this is what you're gonna get, and build them from there. So sell them as the design,
So
not
I
as a
guess, I
lot.
guess what my colleague was saying, these are not lots you're creating and then sell them in the open market and it would be design build. You're gonna design them and build them and sell them as a separate lot with a house on it.
Absolutely.
Because as you can imagine, some of the concerns that we read and have been expressed in exchanges that we filed from the community is that, you know, what's to prevent someone from coming back in the future seeking variances to increase the GFA because a house at 155 square meters, about 1,600 square feet is inadequate for today's modern, we've heard that many, many times, you know, it's a small house for today's modern family, and then you sever them, and then people come back later and ask for a GFA or, you know, a relaxation on the setbacks. They don't fit within the envelope you show.
Right, yes. So I guess in the future, once we've sold it to somebody, that house that we've built, they could ask and see if they could get a variance, but
Or not
I
even
don't think
that,
they would need
or not
it.
even that. If you enter into an agreement of purchase and sale and say, oh, you know, I'll enter into this, but as long as, you know, I need like a 4th bedroom or I need this bedroom this size and it dries up to gross floor area, and all of a sudden you tell us today that, oh, I can meet the zoning bylaw requirements, I can fit within that footprint, I can do the height, and I'm gonna build it, and I'm gonna sell them, but you could also enter into an agreement of purchase and sale that says, I'll only buy this if I can have 170 square meters.
Yeah, I don't see that happening, no.
It's not a potential of happening, or you don't see it at all?
No, I don't see it happening at all. We've done many, many houses in Oakville, and mostly what we do is build them first. And not big houses, they're always small houses like this, and I think there's a great market for it. I think there are a lot of 3,000 plus houses out there that are being built and have been built, but I think people are and will be looking more into smaller homes. The design of this home is got a large kitchen, a large living, large family. You can finish the basement if you want an extra room, but it's got either a 3-bedroom design or a 2-bedroom design.
So
If you
those
want
drawings
4
you have
livers.
there, can you leave them with us?
Yep, yeah, there should be, are they in yeah, they're in the,
Must have missed
we wanted to submit them as, this is what we would like to do, this is what we are going to do. It's hard to say exactly the fenestration and stuff like that because the design is still in a process. We don't want to take it to the nth degree. But it will be exactly the envelope that we've presented. And I think all the drawings are in the,
Yeah, no, sorry, I missed
yeah,
that, yeah.
yeah.
Okay, any further questions? See none, okay, let's just have a seat and
Thank you.
we'll get back to you if necessary. We're gonna give one person a chance to speak and,
So I'll need all his drawings and Nancy's as well.
yeah. Just whatever you presented to us that we don't have in our package, you have to leave with us, because it's part of the record now. Okay.
And Nancy, your stuff too?
No, Miss Friday had something else that she showed, the lot areas in green and red, I think. That, yeah, we'll need that stuff. Yeah, that's now our property. Likewise, if you put cell phones and iPads on there, it becomes our property. So who would like to speak to this, please? Oh, yes, okay, so just, we received an email from Mr. Peter and Mrs. Kathleen Hadley. They asked us to read it into the record, and we will. Would you please convey to members of the Committee of Adjustment our sincere regret that we are unable to attend tonight's meeting. The family medical situation means we have to leave town this afternoon. We wish to reiterate our objections to consent application B1611 and the accompanying application for variance CAVA 180 and CAVA 181 2016, as we stated in our letter dated December 7, 2016, which I think is already in our package. Everyone's seen it. I wish to point out that the RL5 suffix 0 zone regulations are already the least restrictive in our neighborhood in terms of lot sizes. If approved, this application will set a very bad precedent. Sincerely, Peter and Kathleen Hadley. Will enter that into the record. So someone wanted to come down and speak to this matter, sir?
Is there a possibility of a PowerPoint presentation, or are we not set up for that?
No.
I don't have the special cord.
Well, you know what we'll do? You might be able to, if you tip your...
Hey, that's brilliant, thank you. No, that's the best
Can you say that
idea.
again? I didn't hear you.
No, that's amazing.
Daniel, can you help maybe?
That's amazing.
But the presentation needs to be given to me.
No, well, we'll get it
I've
electronic.
got
No,
copies for
no.
everyone.
Let's just proceed with the presentation so we don't hold up the proceeding. But you have to provide an electronic copy, or you have a written? Oh, perfect.
Electronic
Okay.
as well? You're more than
No,
welcome to that.
written's
I
good.
can email you this one, too.
No, yeah, this is fine.
Yeah,
Is this enough to get started?
I hope so.
All right.
There you go.
There we
Okay,
go.
now, unfortunately, I'm gonna have, can you do the button for me, would you mind? Okay, go back up to the beginning. Okay, we're not quite centered, I apologize for
That's okay. I
the
mean,
technical
this
issues.
is good. We also have your written copy that we'll follow.
No, this is more detail and a
There you
little
go.
bit different. There we go, okay. Good evening. Thank you for having this opportunity for our community to address the Committee of Adjustment. And my name is Bill Mary. I live at 266 Spruce Street. I'm also the owner of 279 Spruce Street, which is adjacent to the southeast limit of the subject property, okay? We really have two fundamental issues. And first I'd like to say to the architect, he's not done a bad job. He really has made an effort. I have to give credit where credit is due. And I don't agree necessarily, but there are other issues. Our prime issues are proximity and lot size. And our second prime issue is coverage and green space. Proximity and lot size. Thank you. Next. Okay. This lot is surrounded by lots of the larger lots in the neighborhood. 50-foot frontage, according to MPAC, There may be a slight difference on some of these because I'm not sure whether MPAC always gives us the exact amounts. However, the X is the subject property, and I've drawn a line roughly where the two parcels would be, pardon the crudeness of it. Regarding the proximity lot size, staff comments are the lot configuration created by the proposed consent will result in intensification which is compatible with the surrounding district. I won't read all of this because it'll take the whole time.
No, we read this already, yes.
I'm sorry?
We've already read this in the staff report already.
Right, okay.
Yes.
We disagree with the above statement. It is clear from the town's mapping that all adjacent and opposite parcels, immediately adjacent and opposite parcels, are significantly larger than the proposed severance, and the two small, very narrow lots do not enhance the adjacent and opposite properties.
So
Okay.
just on that point, because and we'll give you time to go
Thank
through
you.
it as well.
Thank
Can you
you.
go back to your other slides? Because I
Yes,
want to
yes, sir.
understand, staff are saying, no, previous slide.
The map?
The one that we
There-
just.
There we go, yep.
No, sorry, my apologies, the one that you were just at. Because it says surrounding area.
Right.
It says
We'll get to
compatible,
that.
compatible with the surrounding area, and you're saying that your definition of surrounding area is different. That's what I want to understand.
No, it's not different. I'll get to that. There's the immediacy. Like, there is an issue of adjacency and fronting, and there's also then the broader area, which I'll get, that's further
Okay,
down
I
in
just,
here.
that's
Yeah,
what I
if you-
wanted
if you-
to
if you-
do.
if-
Thank you.
Yeah, no problem. Staff have acknowledged that both lots are deficient, proposed do not conform with the zoning bylaw. What is not clear is the deleterious effect that this has when you redevelop. The net result of this severance would be frontages of at least 29% smaller than the adjacent and opposite properties and significantly undermine the zoning bylaw. Okay, next. However, under the livable Oakville plan, applications for consent can only be granted where, and you've read the livable plan, but the pertinent section is G, the size and shape of the lot conforms with the requirements of the zoning bylaw, is appropriate to the use proposed, and is compatible with adjacent lots. It doesn't say the whole neighborhood, adjacent lots. Next, please, Ali. Clearly, the application does not comply. The lot size and shape do not comply with the zoning bylaw and is not compatible with the adjacent lots. This proposal does not protect the existing neighborhood character and is out of scale and proportion to the adjacent lots and would continue to be out of place. This is quite important, out of place as the neighboring properties evolve, because they're all 50-foot and more lots. Next. Yeah, next. Oh, okay. As identified in 3.1 of the Scale Design Guidelines for Stable Residential Communities, from the design guidelines, it is clear that long, narrow lots are not desirable as they constrain the scale and massing of the building. And this form is to the discouraged form. Next. So this is straight out from the design guidelines that the town puts out. And you can see down, if you can see the long, narrow building, it's a discouraged form. Anyway, I won't belabor that one. And then further staff comments, conducted a study of frontage areas within the immediate area and subject areas, report identify a number of properties that have lots and areas frontage greater, lesser, and so on and so forth. I won't go through this whole thing, but I'll go immediately to our map. And this is, I believe, what you were suggesting earlier, sir?
Yeah,
Okay.
And I'll tell you where I'm coming from,
Yep.
okay, just to be absolutely transparent. So when you look at the policies in the official plan, and you're familiar with them because you've reviewed them, and you've done a nice job so far taking us to some wording, but there's an intermingle between the words adjacent and surrounding area, surrounding neighborhood. And there's a distinction made in the official plan when you
Right.
look at adjacent and when you look at surrounding area, and they're not the same.
Sir, I'm going to speak to that in this slide.
Okay.
Okay. So all the yellow lots are within the zoning bylaw. You can see that predominantly the zoning bylaw of 50 feet. There are a few lots hatched out which just are under the zoning bylaw. And then we have the 4 heritage lots. None of them are on Engelhart, and they are 35 feet. That is a
Which
fact.
ones are those?
The ones highlighted in these ones here. Oops, sorry, Al. Oh, I didn't realize it would do that. The pinks there, and then the browns up here are all 40 feet.
Okay, and everything
Okay.
else is 50?
Yes. Yeah, and these down here are also new severances, and they're 40. So, okay. Now, one of the things is that the applicant, when they did their study, they included lands, parcels up in the commercial area, which really don't apply. They're not anywhere near the same zoning. So, so we removed 4 of those parcels from our study. This is just the survey, so we might as well skip on. Okay. Sorry, I can't quite see that. Okay. While the applicant provided a study of the lot frontages, the results have been aggregated to favor their position. It also neglected some key points in the discussion of the lots. We disagree with the applicant's analysis and offer below. And really, we're addressing staff's comments, because on Friday we weren't opposing the applicant any longer. We were actually now having to focus on staff comments.
Sir, can I just ask, because you're way past your time?
Yes, sir.
Is there anyone else in the audience that wishes to speak to this matter? So you're sort of the combined group's opinion, if I can say that?
I have 21 signatures on the
Okay.
petition.
All right.
so-
Well, that's
sorry.
fair. Then we'll give you a bit more time, only in fairness
Thank
to address.
No, I
your concern,
appreciate that.
But you should be wrapping up soon. So we
I'll do my very best.
Thank you.
Thank you. So I'll skip over the properties, and we've basically discussed this, so you can skip to the next page, Eleanor. Okay, this is a summary of the lots in the area. 69% are within the zoning bylaw, 50 feet. 6% are 46 to 48, or 6.5 or 48. 15% are 40 to 41 feet, and 9% or 4 of them are 35 feet. Next. Okay. But on Englehart, it's a little different. 15 of them represents 100%. 60% of them are 50 feet. 7% of them are 48 feet. And 5 of them, or 33%, are 40 feet. And then 0 are 35 feet. There are no 35-foot lots on Englehart. Next, please. Okay, we'll skip this one. We'll skip this one as well, because basically, staff has brought up the issue of the original plan of subdivision, and the original plan of subdivision really doesn't bear a lot of weight on this, because as we all know, most of the parcels of land were subdivided in 100 years ago by meets and bounds or deed description. So I'm not going to belabor that point either, because the most important point is coming towards the end. Next, please. Okay. One of the general heritage attributes of the adjacent land is significant amount of green space surrounding the property. This space allows for the planting of trees which can reasonably be expected to reach maturity. The proposal being 29% frontage and 21% less area than the zoning standards will unfortunately result in a built form, even with their falling within the zoning bylaws for their house, of yielding only 32% green space. Experience with recent severances has resulted in buildings of extreme disproportionate scale and extremely limited areas for remaining planting trees. Sorry about this. I apologize, but this is the applicant's drawing, and I've marked out basically the greeny yellow is what would be actual green space. There is open space in the driveway and the deck and so on, but this is the sort of thing that happen when you sever these lots. They get smaller and smaller, and you have fixed amenities that you can't reduce the size of them, and that puts pressure on everything. And if you added on any additions that somebody would build later, it would even be worse than 32%. Okay, this is the property. Once again, I apologize about the crudeness of it. I simply put the 2 blocks together, made one deck, one driveway, one garage, and all of a sudden the green space moves up to 53%. Now, 53% is probably at the percentage of green space around the houses that exist in the neighborhood at this time. Generally, that's what it is. And we've recently had problems where properties have been developed and the builder can't even plant trees because there's not enough space for the trees on the land. Next, Ellie, please. Okay, so I can skip over this. I basically said that. And So in summary, from our experience with recent developments, we vehemently disagree with the above conclusion. We respectfully submit that the application for consent to sever the lands into 2 narrow lots will create significant negative impacts. The proposed frontage and areas do not even come close to the zoning bylaw. The requested variances are not minor in nature, 29 and 21%. The land can be developed as is within the current zoning bylaw, thereby maintaining the green space and the built form environment. As stated in the livable Oakville intensification, it is not the focus in a stable residential neighborhood. There is no positive social or environmental reason for this development. It only serves to increase the aggregate value of the property to the developer. This is not a justification to disrupt the character of this stable residential neighborhood. And I'm not going to reread this. The negation, elimination of the green space by this lotting form has a permanent deleterious effect on the neighborhood. The proposal, if approved, will not fit in with the adjacent and opposite lot frontage and area. The lot as it exists is only slightly larger than the adjacent lot. So the lot as it is right now is only 200 square feet larger than my property on the corner, so it's really not out of scale with the adjacent lands. The progressive frontage pattern from the north portion of Englehart to the south would be broken. You have 40, 40, 50, or 40, 40, 46, 48, and then 35, 35. There's no guarantee that the applicant will not ask for additional variances, thereby creating more impact on the green space. And I'm using the term mini monster home, I apologize for that. The proposed development will not fit in with the adjacent lots as the neighborhood evolves. The proposed dwelling in this application do not provide any guarantee that the applicant will not seek further variances once the severance has been approved. Experience has shown that once the severances are approved, the applicant will undertake to obtain further variances. And I shouldn't say the applicant, someone will undertake further variances, because it has been stated by town staff that a house of 1,600 square feet is not marketable. That comment has been heard many, many times. And so it is of concern. And anyway, that's it. Eleanor, last one. Please do not approve this consent application. And thank you for your time. I apologize for going over, but we had a bit of
No,
ground
that's
to
okay.
cover.
I think in fairness, they had 10 minutes and you
Yeah.
had a lot of material to cover. It's not
Thank
our
you.
normal practice, but we wish to accommodate wherever possible.
Thank you, sir.
Any questions of Mr. Mary? Oh, seems there's a few.
Thank you, Mr. Chair. You focused a lot on this application being inconsistent out of character with the existing neighborhood because it's smaller. The frontage is, 4.3 meters smaller than the typical 15-meter frontage surrounding it, the adjacent properties. Do you not see the same issue with the fact that the existing property is larger than the existing community, and that instead of two houses that are very similar to the existing community replacing a fourplex, that wouldn't be more compatible than one very large out-of-character house?
Well, that's a very good point, sir. I don't agree with that, because all of the adjacent properties are, well, mine is 62 feet wide, the Hadley's is 54 feet wide, and they're quite deep. They're deeper than this property. The properties across the road are deeper, and they're all 50 feet wide. Now, you do make a very valid point. However, there's sort of the example of the photograph that the architect showed of all of the houses, I was looking at them and I realized virtually all the houses that he showed that are very nice houses in the neighborhood are on 50-foot lots. And I thought that was very interesting because that is the built form in the neighborhood. So I respect that he used that as a guideline for his own designs, and that's very good. But those are 50-foot lots. And when you narrow them, you get this effect that's, according to the town's own guidelines, the long, whatever you call that, they're suggesting, sir, that that's a discouraged form.
You excluded a bunch of buildings, and I was trying to follow it there. Could you put that drawing up again?
Oh, yes.
That could show me where, I know you excluded,
actually,
you excluded the commercial stuff to the north, I've got that.
Yeah,
But-
and that's, no, that's it. I mean.
That was it, eh?
Okay, here's the zoning map.
Right?
So, and here's this map, and this map actually shows the commercial land.
Right, okay,
And
so
when
you
they did the
excluded those
study,
ones.
they went up here and went around here, which I didn't think
Right.
really made a lot of sense, because it's commercially zoned.
Right.
It actually doesn't affect the outcome,
Okay.
but the average frontage of the houses on Englehart is 48 feet. If you take all of the existing houses on Englehart based on MPAC and you average them, it's 48 feet. And that doesn't include my property. That does not include my property.
And just clarify for me again, then, the heritage homes that you said were built over 100 years ago that are 35 feet in frontage are which homes?
Yes, sir. All the ones that are 35 feet have a heritage. I'm not sure if it's a designation or a heritage. It's a distinction. These are actually in the heritage district.
Okay.
But this one also has a heritage.
Designation.
Yeah, I guess that's it.
And those ones in orange there, they're not 35 feet?
No. Well, to be totally honest, 284, because of the little piece here, I think
Yeah.
it's 36 feet or something like that. I don't know exactly,
Right.
but if it were, when they got severance, it was basically suggested that it was a 40-foot lot, so who cares? So
Right, okay.
41 foot actually.
I can see that happening. Okay. Thank you.
Thank you.
Anyone else wishing to speak to the committee on this application? Okay, Ms. Friday? Just one item of clarification. In your staff report on page 5, you say subsection 11.1.8A of the OP states, intensification within a stable residential community shall be provided as follows. Is there also policy 11.1.9 as well, in addition to 11.1.8? Because planning staff deal with 11.1.9 in their planning report, so is there like two sets of policies?
Sorry, through you, Mr. Chairman, could you just repeat that? I wasn't sure who you were
I'm
speaking
just
to when
wondering.
you were referring to the report.
Yeah, okay, so your planning report on page 4 deals with section policy 11.1.9, and Ms. Friday's report deals with section 11.1.8A. Are they the same? Are we
Through you,
talking- is
Mr.
there-
Chairman, they're not the same, but it's not wrong that we quoted different policies. Both of us prepared our reports independently with respect to what we felt were the impertinent issues dealing with the application.
No, I understand that, but I just want to make sure that, is there 11.1.8A that talks about intensification within the stable residential communities? And is there one under policy 11.1.9? I asked for the OP, I was going to check that. It's online, yeah.
Sorry, just bear with me
I
one
think they
second.
say the same thing, and I'm just wondering, because they start off slightly different, I'm wondering if we're talking about, it seems like the planning report by Ms. Friday starts off with 11.1.8A, and there's references to 11.1.19. But I'm just wondering if there's just a typing error, or if I'm just reading too much into the policy differential. And I asked this because it basically says the same thing, and I wanted to have Ms. Friday communicate to us her position on the difference between surrounding neighborhood as a policy direction, and then in some policies, it talks about adjacent. So I wanted to know why there's a policy distinction in your view on that. And I'll be asking you the same, Ms. Mihaljevic.
Who would you like to ask
So do you have an
first?
OP there?
I do.
May I borrow that? while you-
I can definitely lend it to you, but if it is acceptable to you, I have those policies here. I can answer that question.
Sure.
And then provide it to you for clarity.
Yes.
So within the town's livable Oakville plan, there are distinctive areas that have been identified for intensification. Those areas have been identified as being our growth areas within the town. So downtown Oakville, Kerr Village, Brawny Village, Uptown Core, and Palermo. However, within that context, we would accommodate some intensification within the stable neighborhood area. So the areas that are generally designated in yellow within the plan. So 11.1.8A, which is a further reference to those guiding principles, indicates intensification within stable residential communities shall be provided as follows. A indicates that within stable residential communities on lands designated low-density residential, the construction of a new dwelling on an existing vacant lot, land division, which is what is before you this evening, and or the conversion of an existing building into one or more units may be considered where it is compatible, which is a defined term under the livable plan, with the lot area and lot frontages of the surrounding neighborhood.
Surrounding, right?
Yep.
That
lot-
uses the
That's how it's
surrounding test.
indicated, it says surrounding neighborhood, and subject to the policies 11.1.9.
Part 19.
No, 11.1.9.
So
The-
there's
That
an area-
plan doesn't,
okay.
that might be a typo on Ms.
Okay,
Friday's
so that's
part.
that's what's throwing me off. It's .9 rather than 19. And I thought maybe there's a different policy that we haven't looked at, so okay. Got it?
So, again, 11.1.8 does go on to talk about other policies where
Right.
intensifications within the stable area can be accommodated. Comments that have been provided to you by staff specifically went into the nitty-gritty of 11.1.9
Okay.
and did not feel it was necessary to reference that particular section, as this plan has been adopted in accordance with the provincial policy statement, which also sets out the guiding principles of appropriate locations for intensification, which we did reference in our report.
Okay.
I'm happy to provide this to you if you feel you,
No, that's helpful
Want to
because
see it.
I asked a question of Mr. Mary and I just wanted to be fair and not frank while I'm asking because I see a policy distinction between having to comply with lotting fabric with the surrounding area versus adjacent because Mr. Mary took us to reasons why to use the term adjacent and opposite versus surrounding area and I just wanted to understand that better.
through you, Mr. Chairman, to reiterate, that policy 11.1.8A speaks to intensification being considered where it is compatible with the lot area and lot frontages of the surrounding neighborhood.
And that's not defined.
Compatible is defined,
No, not
surrounding neighborhood.
surrounding area.
No,
And
that is
neither
a subjective
adjacent,
term.
it just means adjacent.
That's
Yeah,
correct.
Okay. Thank you for that discussion. Is there anything you wish to add to that, Ms. Friday?
Just to apologize for the typo in the quote. That's caused this
It's
issue.
okay, I didn't have the OP in front of me, so I can confirm that, and sorry you went through that painful exercise of trying to figure it out. My apologies. Okay,
Yeah.
anything you wish to add to what you just heard?
Yeah, I think it doesn't do justice to ignore the surrounding properties that there are. Yes, there are a few that are smaller. The historical properties on Spruce, there's 3. They were actually, I guess historically, the corner of Trafalgar and Spruce, that lot was made considerably bigger, and then we have 3 with the historical dwellings on them. And that speaks, the character of an area is a combined of all the features within it. And we're just around the corner from Englehart. We're not that far. And Englehart Street South itself has seen severances and smaller dwellings built on smaller lots. And I just want to reiterate that the lot coverage here is not 35%, but just over 32%. So it's less than the zoning bylaw. And that gives, and the rear yard is 11 rather than 7.5. So every attempt has been made to design a dwelling that met some of the residents' concerns previously with bringing the garage up to the street when garages were at the rear. So we had accommodated that concern. And then bring the house up. It's in the same footprint, the 2 dwellings, as the former 4-plex. And there's lots of open space on the property for landscaping and trees to be planted. So, and I feel that the porch on the front of the dwellings is important as well. It keeps an eye on the street and porches are found throughout the neighborhood in Old Oakville. So I know, yes, the lot frontage is 10.71 as measured 7.5 meters back, but the house has been scaled to the size of that lot. And I really do not believe that there's any negative impact on either property adjacent or opposite. We don't have any issues of concern from one neighbor to the north. We do have Mr. Mary concern to the south. There's considerable trees, rear yard, fencing to provide for negate any negative impact from this dwelling. And I believe they'll actually improve the streetscape as opposed to cause some kind of negative impact.
Thank you. Any questions? Mr. Charlevoix?
Actually, it's a question for you, Mr. Chairman, because I was trying to follow this adjacent versus surrounding thing, and I keep reading back on Mr. Mary's comments, so I'm a little bit confused.
I'm going to help you with that.
Yeah.
You want to hear my comments now or later?
Preferably now.
Okay. So the policy 28.12.2, which Mr. Mary stated, talks about applications for consent to create new lots may only be granted where the size and shapes of the lots with the requirements. This is section G that Mr. Mary directed us to.
Right.
It's where the size and shape of the lots conform with the requirements of the zoning bylaw. So conformity means you got to bring them into conformity, whether it's by a zoning bylaw amendment or by an official, or by a minor variance. In this case, we have a minor variance to make the lots conform. It goes on to say application for consent to create new lots may only be granted where size and shape of lots conform to the requirements of the zoning bylaw is appropriate to the use proposed. In other words, can you use them for residential purposes and is compatible with adjacent lots. Compatibility in this instance means they have to coexist. Can they coexist with each other? The specific policies that deal with the intensification, development, intensification includes the creation of a lot, and development talks about all the policies that we just discussed with Ms. Mihaljevic at section 11.1.9, talks about surrounding area, the character of surrounding area. It's not the adjacent lots. It's a much broader geographic reference and policy. So when you cast your planning eyes, you don't look at adjacent. You look at adjacent to make sure they coexist. But when you look at the wider neighborhood in terms of compatibility, it's a broader net. So it's a different policy direction when you actually get into the nuts and bolts on considering intensification. That's my take on the policies, and I don't know if I have that correct, Ms. Mihaljevic.
Through you, Mr. Chairman, generally that is the approach that is taken. We have to respond to the broader policy discussion with respect to where intensification can be provided. And as indicated from a more broad provincial standpoint, Oakville is a place where growth will happen. Our official plan has decided that most of our growth will happen within growth areas, but we can accommodate some intensification within our stable neighborhoods. Further in, the policies around the consent are really dovetailed with any other supporting planning application, such as a minor variance, that would address those types of concerns. So where that particular comment speaks to the lots conforming with respect to shape and size under the zoning bylaw, the applicant has submitted a minor variance application, which then would be evaluated against the 4 tests to determine whether or not that particular size and shape would be supported and meeting the intent and conforming with the bylaw in that instance. So I would direct the committee then to consider staff's comments on the minor variance application in conjunction with this consent to determine at that time whether or not that particular policy is being addressed with respect to the reduced frontage and lot area.
You have the interplay between the adjacent requirement for compatibility and then the evaluation on a broader surrounding neighborhood context. Hope that helps.
It does, actually. One last question for planning. Do you agree with the statement that the commercial lands to the north should not be considered part of the surrounding neighborhood?
Through you, Mr. Chairman, I'm not entirely certain I agree or disagree. I think that the context in which we've evaluated the application really spoke to the lands that were originally part of the plan of subdivision, irrespective of the zoning that would have been placed at that time. So if you do refer to the subdivision plan that was provided, you will see that this was intended to have an arrangement of lots and the way that the road network was initially intended to do. As indicated by the speakers this evening, obviously the lands in this area have evolved. Zoning has changed, the form of development has changed, and those lot shapes and patterns have changed as well. And that's really what we were looking to describe with respect to the appropriateness of a consent in this case.
Okay, thank you. Any further questions? Seeing none, okay, we'll take this matter into committee. Thank you everyone for your time and your evidence. It's been very, very useful. Okay, who would like to start the process off on, we'll deal with the consent application first. Obviously, we'll deal with the whole bundle, but we'll deal with the consent first, B1611, 401 Englehart Street South. Who would like to proceed with a recommendation? Nobody? Thank you, Mr. Telawski. Appreciate you putting something on the table for our discussion.
Thank you, Mr. Chair. And we're just going to deal with the severance at this point?
Just a severance.
So, Mr. Chair, I'm actually going to move that the severance be approved and with explanation for the community. I do find that the severance meets the requirements of the Planning Act and the town's official plan. There's been a lot said about compatibility. There's been, Mr. Chair, as you know, many OMB cases that talk about compatibility not being defined as the same as. And to my earlier question to the speaker, all swords are double-edged. You've got a lot that's larger than the existing majority on the street, and larger could be deemed as incompatible or even more incompatible than smaller. I actually live in Old Oakville, and the beauty of Old Oakville is that its character is defined by its evolution. I have a 50-foot lot. I've got a 25-foot lot across from me. I've got an apartment building 3 doors down and a group home 2 doors down. Nothing on the street's the same as what's next to it, but it still works. And I fear that a larger home on a single lot is going to be more incompatible than what's being proposed here. And I believe the fact that the severance that's being applied for, that it requires the houses to go through site plan approval process, that actually gives the residents greater protection as to what's going to be approved to be built there, as opposed to the applicant coming back if they were denied and putting in a complying building permit application that nobody in this room has a say in, as long as they meet the requirements of the building code and fit the planning requirements. I understand there's concern that, it's a chicken and egg, something has to come first. The lots have to be created first. There's the concern that the severance application and the plans in front of us don't move forward and something else comes forward that requires variances and they get larger. Unfortunately, we can't deal with that here today. I know historically from my personal point of view, when applications like this have come forward with a substandard lot, which have asked for increases in floor area or decreases in severances. I personally have great difficulty with that. If you're creating a lot that's substandard to what the zoning bylaw says, the house should conform with that smaller size. Someone else could come forward to this committee and seek variances in the future, and obviously we'd have to look at that, and I would expect the community would be back to speak to that. But based on what's in front of us today, I think the compatibility, Mr. Chair, will be there with this application. I obviously highly encourage the applicant to be true to his words and go to site plan committee with plans that are very similar to what's been shown to the committee. But, Mr. Chair, with all that, I'm moving the severance be approved along with the conditions recommended by staff.
And you also further indicate that it meets the test of section 5124, it's not premature and subdivision plan is not required?
Correct, sir.
Okay, that's what I understood. Discussion on that recommendation? Mr. Charlevoix?
This is a bit of a difficult one for me. I have to admit that that I was quite swayed by Mr. Mary's presentation, sir. It was a great presentation. And by the time you were finished, I was sort of leaning more towards you. By the time the chairman had finished, I was sort of leaning more towards him. So I think it's one of these really tough ones, and I'm looking at it from my point of view. And I guess from a personal point of view, I may not agree with everything here, but I do feel that that under the guidelines of the town, under the guidelines of the official plan, the provincial planning, that this is meeting it. It does become a little bit subjective as to whether, is 35 feet enough? Should it be 36, 37, 38? And I'm not here to make a judgment on that. I'm here to say that I think the analysis was fair. And I'm actually going to support this motion for severance. I just wanted, for the record, though, I do want to reiterate what my colleague here said is that I'm going to be here on the Committee of Adjustment hopefully for a few more years, and I will look quite negatively on an application that comes back looking to take advantage of the fact that we created these small lots to then create homes which are now more compatible with the neighborhood.
Okay, that's a fair warning. That's not on the record. Any further discussion? Okay, I just wanted to add very quickly that I think it's important that when we apply the official plan tests, that we apply them in the manner they're intended to be read. And and I think when we're looking and analyzing severances, especially in an established residential neighborhood, we have to follow the direction of when we consider adjacent and when we consider surrounding area. And of course, when we talk about surrounding area, we have to exclude properties like commercial. That's fair. So I think with the discussion we had tonight, the evidence we heard from the public, and the policy interpretations that we had, I think resulted in a fair hearing, and I'm going to support the recommendation for approval of the severances as well. So any further discussion? Seeing none, all those in support subject to those conditions? Okay, that severance has been approved. Can we have a bundle, or we'll deal with the two minor variances, CAV 180 2016 and CAVA 181 2016 for 401 Englehart Street South? Who would like to move those? Mr. Charlevoix, thanks.
Just to take up on all the stuff that was discussed here, Mr. Chairman, I'm going to put forward a motion to approve the two variances you mentioned, finding that they meet the four tests under the Planning Act. And I'm going to approve them subject to the condition that this approval will expire 2 years from the date of the decision. The proposed development does not proceed or a building permit is not issued. And the other condition that the requested variances come into effect upon the granting of provincial consent, which I'm assuming doesn't happen just at this meeting. It takes some time.
And I guess we don't have any plans that we
and-
can attach to it.
And then we don't have any plans, so just
Well,
those
we
two
have,
conditions.
we have building envelopes and sketches.
I'm open to somebody talking about the buildings, but as far as I know, we can't do that.
Well, we do have plans.
But they're not asking you to go.
Okay.
Yes. Oh, but you wanted to go through site plan? Yes, okay. There's your answer.
Sorry, repeat that?
Starting to read your mind. Thank you. Okay, so, subject to the condition that, the one condition on the 2 years, right?
And also that the requested variances come into effect upon the granting of provincial consent.
Right, yes, of course, yeah. Second condition. Okay, discussion on recommendation?
I have a quick question for Kate.
Yes.
Since this application will still go to site planning, isn't it a little premature to request the lot frontage variance?
No.
No?
Through you, Mr. Chairman, to the committee member, it is not premature, as by virtue of applying for consent, it cannot comply with the regulations for zoning. This committee cannot grant consent where it would not conform with that specific requirement. So they come as a bundle. The condition that staff have placed on with respect to that the variances would come into effect on the granting of provisional consent, provided no appeals are filed and conditional approval is then final, then those variances would take effect.
Okay, thank you.
So, back to the recommended approval, subject to those two conditions. All those in support? No one opposed, the application being approved. Wanted to thank everyone for their time. It took a little bit longer than we expected, but I thought this application deserved this level of attention. Thank you. Okay, we'll proceed with application CAVA 199-2016 at 2386 Atasha Court. Good evening. Name and address for the record?
Good evening. My name's Sarah Knoll. I'm a planner with GSP Group. Sarah. Yes. Thank you. It is.
On this application, does anyone here this evening have an interest in application CAVA 199-2016 at 2386 Natasha Circle? Staff are recommending approval that the proposed townhouse dwelling be constructed in accordance with the plans dated October 31st, 2016 as submitted. Anyone here have an interest in this application? Members, do you wish a presentation? You had your site visit, read the report, read all the comments, familiar with the application? Do you have any areas of concern? Is there anything that you used to add to the application, Ms. Knoll?
No, there isn't.
Okay, so I think we're ready to take this matter to committee. Who would like to move a recommendation? Mr. Hardcastle, thank you.
Mr. Chairman, having reviewed the materials, I'm satisfied that the requested variances conform to the four tests, variance conforms to the four tests of the Planning Act, and I'll put forward a motion of approval, subject to two conditions. The first being that the proposed townhouse dwelling be constructed in general accordance with the plans dated October 31st, 2016 as submitted. The second being that the approval will expire within 2 years if a building permit has not been issued.
Thank you. Discussion on recommendation? All those in support? No one opposed. Your application is being approved.
Thank you.
Welcome. Application CAVA 202-2016 at 2545 Kate Common.
Evening, Mr. Chairman. Franco Romano here on behalf of the owner, 2095 Autumn Breeze Drive.
Welcome, Mr. Romano.
Thank you.
Is this your first time here, too?
It is not.
Oh, okay. Welcome.
First time today.
Well, good to see you again, sir. Does anyone here this evening have an interest in application CAVA 202? You do, sir? Are you here to listen? You have specific questions of concern? I'm here to listen. Okay, so you're the owner? I'm the owner of the... Okay, well, why don't you just... We'll get it to do this a little bit unorthodox. Although I am Orthodox, we'll do it unorthodox.
Sorry, Nick Kravchuk. I currently reside at 2549 Kate Common, and I've already purchased the dwelling that they're building, so I'm just here to listen in, I guess.
Okay, because the reason why I ask is because our bylaws allow us to waive the full presentation, as you saw in the other, on Englehart one.
Yes.
But if there's areas of concern and interest, then we'd like to...
I'm just here to listen, that's all.
Okay,
Thank
so
you.
that, so we'll note, so we just...
Purchase 2549?
Yeah, you purchased 2545, is that what you said?
The one that's in question 2 years ago, yes.
Oh, yeah, okay. That's, no, he purchased it 2 years ago, but he lives next door now, right?
If I may, Mr. Chairman, this gentleman owns a property within this development.
Yes.
And has purchased this lot. But this lot doesn't have a house on it yet, so he's going to move into this house.
Right, okay, so you have an interest in seeing
Correct.
what happens in it, okay. So, listen, members, you wish a full presentation, you ready to proceed on the application? You read the staff report, read the comments? Is there anything you wish to add, Mr. Romano?
No, in favor of the comments and
Okay, so the recommendation is to approve, subject to the condition, which I'm sure you've read, Mr. Romano?
yes,
Okay.
in accordance with the drawings.
Yes, yes. Okay, so let's have a recommendation on this. Was that your hand, Sherry?
No, it's,
Oh, sorry.
well, hang on, it is.
Okay, Mr. Chairman.
Thank you.
I'm satisfied with the material as presented before us. I do feel that the application does meet the 4 tests of the Planning Act as well as the official plan. I will move a motion to approve this application with the condition that the proposed well be constructed in accordance with the plans dated November 3rd, 2016, as submitted. And our standard
Subject to 3 years? 2 years, sorry?
Yes, subject to our regular approval that they will expire within 2 years if the date of the decision has not been proposed, the development has not proceeded and/or building permit not
Obtained?
obtained.
Okay,
Thank you.
discussion on our recommendation? Seeing none, all those in support? No one opposed, so your application's been approved.
Thank you kindly.
Thank you. Application CAVA 204, 2016, 1130, 8th line. This is for a sports facility with a swimming pool.
Yes.
Good evening, sir. Name and address for the record.
Yes, Chair Chronis, Victor Labreche from Labreche Patterson and Associates.
Mr. Labreche, is this your first time here?
8 years ago.
Okay, so it's your
been a
first time
while.
today?
Yes.
Okay, thank you. Yes, Ms. Savage.
Thank you, Mr. Chairman. With your indulgence, I would like to point out a small error in the recommendation that's been provided to you this evening before Mr. Labreche proceeds with his discussion. You will note that the condition addresses a dwelling. That is not what is happening here. There is no dwelling proposed.
No, yes.
And I do apologize. Any condition that the committee may choose to impose with respect to the required permit, they do need a building permit to change the use, would be totally acceptable. Staff do not provide any additional conditions on that effect.
Okay, thank you.
You're welcome.
Do you have any questions, Mr. Charlebois? Let's just see before we proceed on questions. Other than Mr. Labreche, who we see for the first time today, is there anyone here this evening that has an interest in application CAV 204, 2016? You do, sir. Are you here in support and opposition?
Support.
Okay. Can we get your name and address for the record? The new requirements of the Planning Act require us to record everyone that's here in support and opposition.
Is he the owner?
I don't know. We'll find out. Are you the owner?
Yes.
Okay.
Dave McKay, MCKAY,
Okay.
and live in Burlington.
Okay. Welcome, sir. So are you the owner or the operator or the tenant?
Both.
Oh, both. Okay.
Yeah. Not the owner of the land, excuse me. We will be the tenant in the
tenant,
facility.
tenant and operator. Okay. Of
Yeah,
Unit
tenant
17
operator.
or whatever it is for the sports facility?
Correct.
Okay. Thank you.
And we represent Mr. McKay.
He's your client?
Correct.
Right. So Mr. McKay's address is?
Is 4497 Concord Place in Burlington.
Okay. Thank you very much. Sir, I don't think we need a presentation. Members, do you have any further questions? Yes.
It's a question for planning. Just wanted to know if we approve this variance, is the variance attached to the use? In other words, if the use leaves, will the variance still stay? I mean, I read it as it does, but I just wanted to confirm that.
Through you, Mr. Chairman, this particular variance is not tied to the specific use. The variance that's being proposed to you is tied to the property as it pertains to all uses that would occupy any of the units and buildings that are within the entire lands. So they have asked for a rate of parking, which would not be specific to the use, but rather to the floor area that would be provided within the whole site. Perhaps Mr. Labreche could also elaborate through his justification report, but that is the nature of the variance before you.
Sure. And we're dealing with Unit 17 or Unit 18?
With Unit 17, sir.
Okay, because the plan shades Unit 18. Was there not a previous approved sports facility in this area? I remember we had one a few years ago.
Through you, Mr. Chairman, there
Skating rink.
I believe it's a hockey training facility.
That's what
and
I
it is
thought, yeah.
located in one of the units of the larger building that is on the most western side of the property. It is
Okay.
under 1,000 square meters in size.
Right,
So the
okay.
only variance that it had required was with respect to parking as it
Right.
related to that use, which was to see a reduction in parking from 24 spaces down to 5.
Right, so
which
we're
was
looking
approved
at-
by this committee.
So we're looking at the all the uses on the site, which is what I believe Mr. LaBreche's report does. It summarizes all the uses, and it provides the available parking, and then rationalizes that this can only provide whatever is on site effectively, and they're requesting a reduction to accommodate the tenant use. Is that a fair summary?
That's correct, yes. And just for the record, the hockey school, the other sports facility is Unit 11 in the longer sort of jagged-looking plaza on
So,
the site.
so let's say if this unit is no longer used for the swimming training facility, then if you want to re-tenant this unit, or the owner wants to re-tenant this unit, they have to go through the same justification if there's enough parking.
Sorry, through you, Mr. Chairman. No, that they would not have to go through the same justification. The assessment that's been provided for you this evening and what Mr. LaBreche has prepared is an analysis of what the parking rate would be to allow for flexibility in the change in use. This is to help facilitate and avoid, frankly, vacant buildings that would otherwise be occupied by uses where the general use of the property has an abundant or overage of parking availability. So instead of providing for a rather difficult process on a per unit basis for people to come in and future tenants, this allows for some flexibility in the changeover of those units and allow for a quicker occupancy.
So a ratio.
Correct.
Yeah. And you represent the tenant, not the owner. But you have the owner's consent to bring the application.
Yes, Mr. Chair, we do have their consent, of course, and we did have a sort of pre-consultation meeting with staff, including Lynn Rogers from Transportation Engineering, to go through how we would approach this analysis, and that, again, was done in August.
Yes.
Our observations on site, I personally did those observations along with Pyramid Transportation, who did the counts, and as noted in staff's report and also our parking analysis, rarely does the site, for unknown reasons, but rarely does it achieve 50% parking utilization, even at peak times. And on the weekends or in evenings, it's around 25%.
Correct. Okay, any questions? Who would like to move a recommendation?
Mr. Chair, I'll move the application be approved as applied for, finding that it meets the 4 tests of the Planning Act, and noting that there is no objection from the public, and would make it subject to the condition that a building permit issue within 2 years.
And at the, 2 years, yep. Okay, any discussion on recommendation? See none, all those in support? No one opposed, your application being approved, sir.
Thank you to the committee and to staff for their considerations.
Good evening, sir, thank you.
Thank you.
Okay, we're dealing with the application at 143 Leyland Avenue, CAVA 143, 2016. This was deferred from our agenda of September 13, 2016. Good evening, sir. Name and address for the record.
Graham Barrett, 22 Close Avenue.
Okay, sir. Is there anyone here this evening that has an interest in application CAVA 143, 2016 at 143 Leyland Avenue? Okay, it seems, sir, can you just quickly bring us up to date what happened during the interim deferral?
Sure, absolutely. When I appeared before you previously, the planning department had some concerns about accuracy of the site plan as prepared. There were also concerns from Halton Conservation. Since then, a proper survey was completed, resulting in a corrected site plan, and Halton Conservation has provided a clearance letter for the property.
Seems like, is there any questions? Yes, Mr. Charlevoix.
Sorry, Mr. Chairman, but again, back to planning. You've got a comment in here that the plans provided by the applicant indicate a number of additions to the front and rear of the dwelling. It is unclear if these additions have been evaluated with respect to lot coverage and residential floor area. So we had this deferral to correct some things, and then you identified further things that possibly, like I'm trying to understand, you know, if you were unsure, I guess, about lot coverage and residential floor area, how can you make recommendations about approving these variances? Because they would have an impact on that stuff.
Through you, Mr. Chairman, to the committee, for that exact reason, the initial application as presented was to address a portion of a front porch that had been constructed without a permit, and additionally, with respect to recognizing some structures that, accessory buildings that were in the backyard to legalize some certain conditions. At that time, it was unclear, based on some aerial photos and what materials had been prepared by the applicant, things just didn't match up. So we had asked them to go away, get a survey done to clarify some of those elements, which they have. However, what they also did with this application is now indicated that there are other additions and possible changes to the dwelling that now are also proposed. That being said, that is not the nature of their application as it was presented to you or to us. The nature of their application is to recognize that front porch and those accessory buildings. So staff just wanted to clarify that by providing our advice to you in supporting the application as submitted, which was to deal with coverage of accessory buildings and the front porch setback, we are no means also identifying an approval or an assumption of any support to any additions that may or may not have been evaluated for residential floor area or lot coverage.
And when do those evaluations occur?
At the time that a building permit would be issued, I would suspect. It has not been done, as far as I'm aware, with respect to this variance application.
So these are just proposed additions. These aren't actual constructed additions.
It's unclear.
It's unclear.
So I can answer that if you'd like.
Okay.
Sure.
So there are proposed additions in the rear to fill in these canopy areas, as we're labeled in the survey, and also this section here, which on the ground floor and the second floor. They don't result in any new variances. We've spoken with Matt Rubik in zoning. He's been over this. It would have required a variance under the old bylaw. Let me just see here. It was 0.1% over for floor area under the old bylaw, but under the new bylaw, it is 0.1% under. So it essentially maxes it out, but it does comply, and it's been through zoning. So
But
no
what
new
you have
variance.
here is a flag, if you will, from staff that planning staff are not going to provide an opinion on zoning compliance, and they're going to defer that for your building permit. And you may have a level of justification. You may or may not be successful. If not, it looks like you may need to come back. But staff are only assessing the application as they understand it, and not taking a position on anything that may have been done there in the past. That's the way I read your...
Right, well, from what the designers have done here, that portion complies, so.
And why were these, and you've known about these matters, why were they not cleared up as part of the last deferral?
That I don't know.
You need to find out in the future, because you know, you've been here many, many times before us. You know that we're going to be asking these tough questions, so.
Right, well, there's no variance on the table, so.
There isn't, but we also have an alarm bell that goes off that says you may need some, so, you know, we don't like to have bifurcated considerations of applications. Maybe our view on the entire package, if you need more variances, only speculation, might be different than if we look at them one at a time. Right, so it's just for the future. Now we're going to deal with the application that's before us. Any questions, any items of clarification?
I just want to tie in with what you said, because you said you spoke to zoning about the additions, and you got some feedback from them that they'll comply. That feedback, did that take into account that this committee might approve the lot coverage for the accessory buildings to be expanded to 9.63? In other words, so the total coverage will still stay the same? I mean, this is, just so you understand, you know, I mean, this is what I want to be sure of, is that if we say, great, you can do 9.63, and all of a sudden, the existing building in the 9.63 exceeds the coverage, and if I'd have known that, maybe I wouldn't have said yes. But if it doesn't exceed the total coverage, then, you know, maybe I would have said, okay, you know, I'm not giving away my position here, but the whole point that I'm concerned about is that if I say yes, do I immediately create a coverage problem because I just didn't bother to ask the question whether the combination of the existing building and this exceeded the coverage, because planning won't tell me
No,
how big the building is.
From what I have here, total coverage between the existing house, the proposed addition, and the accessory structures comes to 28.56%. The max is 35.
Confident that you can make it comply?
Yes, from conversations with zoning, it complies.
Okay. All right. So unless there's anything else to add, we're going to take this matter into committee and issue a decision on it. Who would like to move a recommendation?
Oh, also, sorry, before I have letters of support from 10 neighbors.
Okay. Yeah, file those and that diagram and that picture you have there.
Absolutely.
And who would like to move a recommendation?
Mr. Chairman, if I may, sorry, just to add one item of clarity with respect to staff's condition. Given the explanation provided by the applicant with respect to where the additions are already existing, and based on the image he provided, it appears that it includes the enclosure of a lot of covered areas. I want to just stipulate with respect to staff's condition that it should, as amended, read that the existing accessory buildings and front covered porch be constructed in accordance with the plans that are submitted, that we were dealing with a front yard covered porch, not with respect to any rear yard conditions.
Right. Mr. Bear, you understand that?
Okay, yep.
Yeah, but just for clarification, those things are already built, are they not? We're talking about, everything here says existing.
Through you, Mr. Chairman, to the committee, a permit is required for these items. A
Right.
permit had not been obtained. So a permit, in applying for said permit, we would want to ensure that that permit complies with the drawings and the
Right.
approval that you may be granting this evening. And in such, I would want to make sure that the approval, if granted, would be to the front covered porch,
Yeah.
not to any additions at the rear, which includes covered porches.
Right, but to clarify, normally the building permit comes before you construct. In this case, it's constructed and we're applying for a building permit in arrears. Okay, I got it. Sure. Mr. Chairman, this is perhaps a little bit irregular, but I think I get it, and I'm going to take the presentation here from the applicant, as well as the town's identification of the problem, but notwithstanding that, they seem to feel that they're comfortable enough to support this variance. So I'm going to agree and put forward a motion that this thing be approved, finding it meets all four tests on the Planning Act, subject to the condition that the approval will expire 2 years from the date of this decision if a building permit is not issued, and subject to the condition that the existing accessory building and front covered porch that is already constructed be in accordance with the plans dated November the 23rd, 2016, as submitted.
Discussion on that recommendation? Seeing none, all those in support? Those opposed? Ms. McHale is opposed.
Thank you.
Your application being approved.
Happy holidays.
Motion to adjourn? We have no minutes. Motion, Mr. Charlebois. All those in support? No. We have an adjournment at 8:45.